Hi, Mr. De Le Garza. How are you?
Fine, thank you. How are
Mr.
you?
De Le Garza, you testified a moment ago that you are familiar with the Texas Whistleblower Act, correct?
Yes, I did.
And you understand that the Texas Whistleblower Act affords protection to people that go to law enforcement so they can go to law enforcement without retribution, right?
Yes.
And as part of the Texas Whistleblower Act, that protection only extends to people who still have their job.
Yes, they are, yes.
Right. So what I mean is, if you report someone to law enforcement and they still have their job and then they're retaliated against, they are protected by whistleblower, correct?
If they comply with the retaliatory, the requirements in the Texas Whistleblower Act, yes.
But if they get fired before they go to law enforcement, they're not afforded the protection of the Whistleblower Act, correct?
Right, it has to be, right.
Right, so before you go to law enforcement, you don't want to tell your boss, I'm going to law enforcement.
Objection, speculation.
Sustained.
Under the Whistleblower Act, if you tell your boss you're going to law enforcement, you get terminated, then you go to law enforcement, you're not entitled to the whistleblower protection, correct?
Objection, speculation. It's the same question, Your Honor.
Just said he knew this.
You can answer if you know.
All right, could you just repeat the question, please?
Sure. Under the whistleblower statute that you said you're familiar with, if you tell your boss, I'm about to go to law enforcement, then you go to, before you go to law enforcement, you get fired, then you go to law enforcement, you're not entitled to the protections of the whistleblower statute, are you?
I guess you could make the argument in court. I'm not sure how successful you'd be.
But you agree with my statement, correct?
Probably wouldn't be the best way to do it.
So if someone were to stand up here over and over,
Witness needs to speak up when you speak.
Oh, excuse me.
if someone were to stand up here over and over and say, why didn't you just call your boss? Before you went to law enforcement, why didn't you just call your boss? Under the Whistleblower Act, that wouldn't be a good idea, would it?
I mean, if your plan was to file a lawsuit, then yes, you shouldn't do that.
You should not go to your boss first.
If you were planning to file a lawsuit, I mean, it depends on the situation.
I'm not talking about a lawsuit. I'm talking about whistleblower protection. It would not be a good idea to call your boss first, right?
Objection, asked and answered.
Overruled.
Right?
You're asking me to speculate. I'm not sure what a plaintiff should or shouldn't do.
You don't want to answer that, do you?
I'm not here to, speculate as to what a potential plaintiff under the Whistleblower Act should do or could do.
Just so we're clear, you're not here now. A moment ago, you were okay with it, right?
Objection, Your Honor. It's argumentative.
Sustained.
All right, let's put up AG 120, please. Can you see AG 120?
Yes.
This is a document that you created, an email, right?
Yes.
And in this email, it says, here are my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection, correct?
Yes.
This is your analysis.
This was a privileged and confidential document that we are brainstorming.
I appreciate that, but I think I wrote down your words, and what you said was, this is my analysis. You still stand by that?
Sure.
And you said, I stand by that today.
Yes.
And you said to the senators here, this is the correct analysis, right?
At the time, I believed it was the correct analysis. So
This argument, this exact argument that's in this document right here, was made in the court, right?
I'm not sure. I wasn't involved in that.
You're not familiar with the Court of Appeals case, Office of the Attorney General versus Blake Brickman, Mark Penley, David Maxwell, and Ryan Vassar? You're not familiar with that?
I am familiar, but I wasn't involved. I didn't work on that appeal.
Are you familiar with the decision that came out in that appeal?
I would have to read it, and
You don't remember?
to be honest, I'm not sure if I carefully, that was not something that I needed to read.
Well, if you had read it, you would know that the Court of Appeals said all of your analysis in AG 120 was wrong. Right?
Objection argumentative.
He knows,
Overruled.
right?
It happens as lawyers, we make arguments and courts don't agree with them. And so, there's always going to be a winning side and a losing side. And at the time, I was just coming up with potential arguments. That's what, we do.
Right, so when the senators are deciding whether or not this is a valid argument, they can disregard it because the Court of Appeals already decided it was not.
Objection. This misstates testimony and is going outside of direct. This also is talking about a document that is not in evidence, and there's been no testimony before this witness about.
Overruled.
Right?
I defer to the Senate to do the right thing.
You spent a lot of time telling us about how people were involuntarily separated. That means fired, right?
Yeah, we just like to use involuntary separation.
Okay, I just want to make sure we're on the same
Yes.
page. That means fired.
It does.
You also spent a lot of time using the phrase, based on facts presented to me, right?
Yes.
And those facts were presented to you by Brett Webster.
For the most part, yes.
Doesn't it seem like you had a Brett Webster problem?
Well, he was the new first assistant, and these employees were reporting to him.
I mean, you've heard the term garbage in, garbage out, right?
I've heard the expression.
So if Brett Webster is giving you information that's not true, then your analysis is wrong, correct?
I have to rely on the information given to me.
I appreciate that. My question is a little bit different. If Brett Webster's not telling you accurate information, then all the analysis you gave on direct examination is all incorrect.
Objection. Speculation.
He knows,
Overruled.
correct?
I have to rely on the facts presented to me, and so
Is my
Yeah.
question difficult?
it's you're saying that if he presented false information to me, and I'm using that false, yes, it could affect my analysis.
Well, let's talk about the real reason why these people got fired. Stacey, can you put the timeline up, please? I'm going to use this for demonstrative purposes, so...
Your Honor, I'm going to object. I've never seen whatever this is before. Counsel and I discussed exhibits during the break. This was not provided to me, so I would request that we get a copy of whatever this is to quickly review.
Not an exhibit, Your Honor. Simply demonstrative purposes, not going back based on dates that this witness provided on direct examination. If the dates are wrong, counsel can correct me.
Well, Your Honor, I mean, we might have an objection to whatever he's going to put on this timeline. I don't know what it is, and I don't have an opportunity to verify it, and it's being published to this jury as if it's fact. So I'm going to object to displaying this to the jury.
Your Honor, they're making evidentiary arguments. I'm not offering this into evidence. It's purely demonstrative.
Your Honor, this...
Hold on. Don't talk over each other. I think you can provide the counsel with what you're about to show. Yes.
Thank you. Your Honor, I might have objections as this goes along because I don't think there's any foundation that he's laid yet, at least, to ask to publish these as something that's within this witness's personal knowledge. But subject to that, I appreciate counsel providing this copy, and we can move along.
Move along.
Mr. De Le Garza, on September 30th, and just before we get started, I want to point out this timeline is a...
Yes.
Stay at the microphone.
Yes. I want to point out, Mr. De La Garza, that this timeline is roughly a month and a half, less than a month and a half. Do you see that?
Yes.
And as you are familiar with the whistleblower statute, as you testified in direct examination, I'm sure you're familiar with 554.004, right?
Could you remind me?
Sure. It says In an adverse action, if within 90 days of reporting to law enforcement, there is a presumption of retaliatory conduct.
There is a presumption that can be rebutted.
And so the law says if within 90 days of reporting something to law enforcement, you're terminated or have an adverse action, we are to presume that was retaliatory, right?
There's a presumption.
So September 30th, the whistleblowers go to the FBI, right?
I'm not sure. I have no personal knowledge of what they did.
The head of HR, you don't know?
That's what I heard. That's what they presented to my boss, a letter saying that they had gone there.
Let's start over. You're the head of HR, right?
Now, yes.
You know that they went to FBI on September 30th, right?
I have received information that they did. I have no reason to disbelieve that.
You also know on October 1st, the whistleblowers notified HR and the AG Paxton of the FBI report, correct?
Yes, I believe it was the first.
The next day, Mark Penley and David Maxwell were placed on administrative leave.
That's correct.
On October 13th, David Maxwell made his formal complaint against Ken Paxton.
I'm not aware of exactly when he did. Formal complaints go to the formal complaint officer, so if you say it was the 13th. But
You spent a lot of time telling us about David Maxwell. You reviewed all the file. You're telling me you don't know when David Maxwell made his formal complaint?
I don't have personal knowledge of that because formal complaints go to the formal complaint officer. They don't go to HR.
Well, we can assume by the fact that your lawyer hasn't stood up and objected that that's the day he made his formal complaint, okay?
No reason to disbelieve that.
October 15th, Brickman, Vassar, Bangert, McCartley, and Penley all file formal complaints. You know that as well, right?
I understood that they all filed formal complaints.
October 20th, so 20 days after going to the FBI, 19 days after the whistleblowers notify of the fact that they went to the FBI, Blake Brickman was fired, right?
Yes.
Lacey Mace was fired.
Yes.
November 2nd, a month after going to the FBI, David Maxwell was fired.
Yes.
November 2nd, a month after going to the FBI, Mark Penley was fired.
Yes.
November 17th, 6 weeks after going to the FBI, Ryan Vassar is fired.
Yes.
Have you ever heard of the expression, there's no coincidences in Austin? Pass the witness.
Redirect.
Just briefly, Your Honor. Mr. De La Garza, did agency policy support the termination of Lacey Mace?
Yes.
And did you recommend that termination?
I did.
Do you stand by that recommendation today?
I do.
No further questions, Your Honor.
Are you,
No need for it.
okay, we can excuse the witness?
Yes, Your Honor.
Yes? You may step down, thank you. A little housekeeping before the next witness. I said that after the break, I would admit 702 into evidence. We did not do that, so 702 is admitted into evidence. Mr. Donnelly, I think that was the correct number. Also, if both parties would like to come to the bench for a moment.